Dear friends, colleagues, and students, here is Jing Huang from the City Center of Asia and Pacific Law of the Sydney Law School. I'm very pleased that you attend this session, which was actually organized in the late Friday. Happy Friday. And today we are going to focus on private international law and intellectual property. Especially, we jointly organized this event with the International Law Association Australian branch. The focus of today is we are going to discuss the significance and challenges and issues for the Kyoto Guidelines. Last year, the 17th Conference of the International Law Association passed the resolution and adopted the guidelines on intellectual property and private international law. We call it Kyoto Guidelines. The guidelines are part of international efforts to establish a cooperative global system for jurisdiction, choice of law, and judgment recognition and enforcement in transnational intellectual property disputes. And it draws important insights from predecessors' projects, such as American Law Institute Principles on Transnational Intellectual Property Disputes. Very important is join the Korean and Japanese principles and many other previous international efforts. So today, it is really my honor to have three distinguished professors specialized in private international and IP to discuss the practical cases and challenges and significance for the Kyoto Guidelines. And our first speaker is the Professor Toshiyuki Kono from the Kyushu University. Professor Kono led the Committee of International Law Association on intellectual property and private international law. And I'm very pleased to be part of the team of Professor Kono. And our second speaker is the Professor Kyushu Lee from the Chang'an University. Professor Kyushu Lee has significantly contributed to the guideline, and later I'm going to distribute while the chat function of the papers written by Professor Lee regarding the guidelines. And our third speaker is our old friend, is my colleague, Professor Vivian Bass. Professor Bass was the longtime leader of the Centers of Asia and Pacific Law. She is the leading professor of private international law in Australia. She has discussed the intellectual property and private international law in many parts of the world, recently in the United States, in China, and now, here we are in Sydney University. Okay, so the profiles of our distinguished speakers are available online. I'm not going to spend more time here because they are truly very leading speakers. So let me turn my floor to our first speaker, Professor Kono. And I believe Professor Kono will discuss, you as a general overview of the Kyoto Guidelines. And our second speaker, Professor Lee, will focus on the jurisdiction issues, especially using a Korean case. And Professor William Bass will focus on another important jurisdiction issues, which is injunction. Okay, so now let's turn the floor to Professor Kono. Also, I welcome all the attendees to post your question at the chat function, and our speakers will answer your question while chat. And some of the questions we are going to adjust at our last QA session. Okay, Professor Kono, please.
Thank you very much, Jen, for your kind introduction. Good afternoon, everybody. Thank you for joining this webinar. Please allow me to share my PowerPoint slides, first of all. Oops, sorry, it's not. Sorry about this. I hope you can see my slides.
Yes.
Okay. Okay. So my presentation aims at showing the background and significance of Kyoto Guidelines, and I start with the concrete case. This is as you see that the George Lucas film Star Wars, and this is a Lucasfilm versus Ainsworth. And in this case, the Mr. Ainsworth created this helmet design for George Lucas film. However, he started to sell the helmet for his personal business. So he was sued by the Lucasfilm in United Kingdom. The issue was infringement of copyright, especially US copyright. So there are two big questions, and one is the justiciability, justiciability of foreign copyright claims. For in this case, the US copyright infringement can be the issue at US court and UK court. And another one is a jurisdiction issue according to the Brussels I regulations. The Court of Appeal rendered the judgments, and the claimants lost the case. The reason of the UK, the Court of Appeal, was that the foreign copyright related claims are not justiciable at the UK court. And the traditional common law rule, i.e. the Mozambique rule, still applies. And in this case, the Mozambique rule was created in a case called the British South Africa Company versus Companhia de Mozambique in 1893. It was about a dispute of the land in Mozambique in Africa. And this rule was applied in a patent infringement case in Australia, in the case Potter versus Broken Hill. So the rule established by these cases was also extended to the copyright, and then because of this rule that US copyright, the claim based on the US copyrights was not allowed at UK court. However, the Supreme Court took a different approach, and there are several questions like this in this case. But as you see here, first of all, that the court said that the basis for the decision in the Potter Broken Hill company has disappeared, and also in the US, in the case of copyright infringement, the act of state doctrine has no application, and also the foreign act of state doctrine should not today be regarded as an impediment to an action for infringement for intellectual property rights. So at least the intellectual property, which does not need registration like copyright, even it is in a foreign one, can be claimed at UK court. So this is a pretty sensational judgment for the common law. I would like to show another example. This is called the Mangamura. And this is not a litigation case, however. This Mangamura was a website where the thousands of mangas and novels were available for free. And it was opened in January 2016, and it was closed all of a sudden in 2018. And a big number of users visited this website during these 2 years, and monthly users, the number of monthly users was about 100 million people. So in this case, it was discovered that the contents were provided by Cloudflare, as a company in California, but the server of Mangamura, this website, was located in Ukraine. And the server was contracted by the Swedish service provider. The owner of the website was recently arrested in the Philippines. So this case shows that the copyright infringement could be easily occurred in such a global scale and also worldwide, and the facts could be very complicated. And in this case, there's no civil litigation so far, and the criminal case, as it was raised, it was actually broadly reported as a criminal case, but it can be also a civil litigation as well. So here, these two cases imply us that the following issues and implications. Well, first of all, the principle of territoriality of intellectual property does apply. However, the market is very globalized, and especially now, there's you see with the internet, the market is really becomes very global, and the harmonization of the level of protection of intellectual property has been well progressed. On the other hand, in the field of private international law, it was not the case. And these two cases actually show that there's a need for more thoughts and discussions about intellectual property and private international law. In fact, there were discussions and projects to tackle these issues. And the first trial was the Hague Judgment Project, which started in 1992. And at that time, the Hague Conference on Private International Law tried to draft convention in the style of so-called a mixed convention, i.e. dealing with the jurisdiction and the recognition of foreign judgment in one instrument. But over a 10-year-long negotiation, it failed. And it ended up as the 2005 Convention on Choice of Court Agreement. The starting point, very big project, but it ended up as a very so-called mini convention. And one of the difficulties in the negotiation was intellectual property, how to deal with intellectual property in a framework of an international instrument. And later, the Hague Conference also launched a project, in this case, focusing on the recognition and enforcement of foreign judgment in civil and commercial matters. And it was adopted as a convention. However, it is not yet in force. At the beginning, the draft of this convention had a chapter or provisions regarding properties. However, at the end of the negotiation phase, this intellectual property issues were excluded from the scope. So still, on a global level, intellectual property, how to deal with intellectual property issues is still not properly regulated. So there's a lacuna in this case. In order to fill this gap, as Jane has already explained in her introduction, some groups of scholars tried to fill this gap. And the pioneer work was done by American Law Institute, and the ideas were actually drafted as the guide, the principles of American Law Institute. It was published in 2008. And equivalent efforts were made in Europe, and it was published as Conflict of Laws, Intellectual Property, the CLIP Principles and Commentary in 2011. And in Asia, there was a project that's Korea Japan. The project also with the aim to draft soft law, and also the project called the Transparency Project. This is actually to make a legislative proposal for Japan. These four projects have similarities, but they were rather regional trials. So in order to create a real global, let's say, the framework, the International Law Association launched a committee to draft the soft law, and it was adopted as a Kyoto Guidelines in 2020. It is the very first global soft law instrument, I would say. And this, in this journal, GP Tech, these guidelines and the commentaries published in January this year. And this is the first page, front page, and on the left-hand side, on the right-hand side is the list of members. Jane and Professor Lee and then myself are on this list. And now these Kyoto Guidelines are translated in 6 languages. Originally, it was drafted in English. Now these are translations available at the website of my university. You can find the URL at the top of this one, and I am more than happy to share this link later in the chat box. To conclude, I would like to share this as a piece of information. International organizations started to, especially the WIPO, started to recognize the importance of this issue. So they jointly published a guide for judges to deal with private international law and intellectual property. So if you are not familiar with any of this law field, I would suggest to get these documents. This is available for free, and this is a very easy, let's say, easily understandable, let's say, guidebook for users before you visit this GP Tech and comment the guidelines and comments. So I stop here. This is this is the background and of these guidelines. And the significance is that I would repeat that this is our first global instrument, and soft law instrument, and it fills the lacuna of hard law. So we all contributors hope that this will play an important role as an instrument for legal scholars and practitioners. So I stop here. Thank you very much for your listening.
Thank you very much, Professor Kono. The journals that Professor Kono discussed just now, and I already upload to the chat function. I see we have some attendees already post their questions, and I invite our panelists to answer their questions. And thank you, Professor Lee, who already posted the answer. And now let's turn the floor to Professor Lee. So please, Professor Lee.
Okay. It's a long slide, so I skipped several parts. Maybe you can refer to my presentations, which is a more detailed, explanation for the Kyoto Guidelines. Today's focus is are two. One is the law applicable transferability of intellectual property right under Kyoto Guidelines. The other focus is the law applicable to employment contract under the Kyoto Guidelines. Those are prescribed under the guidelines 19 and 23. So today's focus is not about is not on the Korean case law, but it's in order for you to understand the Kyoto Guidelines better. I cited two Korean cases. Actually, the first one is kind of the inconsistent with the Kyoto Guidelines. The other is definitely consistent with the Kyoto Guidelines. So it might be very beneficial for me to mention two cases. So according to the guidelines, guideline 19, the law applicable to determine transferability of an intellectual property right is lex loci protectionis. So Professor Kono explained transferability of intellectual property right should be separate for the contractual agreements. So what is the difference for between the transferability and transfer, actual transfer? So this is a very good example. Inheritance and the split of a company is a non the contractual setting. So those kind of the transferability issues will be governed by the lex loci protectionis. So what is the lex loci protectionis? So actually, for example, for the patent, so actually the lex loci protection is the law of the state where the registration was made. So this is a very interesting case. It is called Actors Soft versus Chungi IP case. So it's still pending before the Korean Supreme Court. So the Korean Supreme Court is very carefully look up to the the ILA guidelines before to determine this case. The legend of the mirror. Mirror is mirror means the dragon in Korean is the pure Korean words. The legend of the mirror too is a game co-created Actors Soft and the We Made Entertainment Inc. Here, Actors Soft and the We Made Entertainment Inc. Both of them are the incorporated in Korea. it looks like they're Korean companies, but the Actors Soft is incorporated by the Chinese company. So basically, the look up to the what is it? Apparently, it looks like a domestic case. However, it's not a domestic in reality. So actually, the Actors Soft is an investor for this game. We Made is a creator. However, under the contract between them, is they said, oh, we are the co-author, like that. So it's very complicated. Anyway, the Actors Soft and We Made were incorporated in Korea under the Korean, the 500 Article 530-20 of the Korean Commercial Act prescribes the split of the company. Problem is, under the Chinese company law, there is no provisions about the split of the company. So that's why the one side, maybe plaintiffs want to apply the Chinese law, but the Korean company actually want to apply to Korean law. So the other one is Article 48, paragraph 1 of the Korean Copyright Act. Inscribes no holder of author's economic right shall be entitled to transfer by assignment, without his or her share of the author's economic right without consent of the other authors. This is important. It's a kind of the two articles actually mandatory provisions. So we should decide which provisions takes precedence over the other provisions. How about the Article 4 of the 24 of the Korean Private International Law? It prescribes that the intellectual property shall be protected by the law of the place where the intellectual property was infringed. It looks like it only describes of the lex protectionis, only in terms of infringement of intellectual property rights. However, most the academicians in Korea just interpreted this provision as the we prescribe the lex protectionis in terms of all intellectual property issues. But court. The Korean Supreme Court never decided, this issue yet. So I think this Actors Soft case is going to be first case to settle this split decisions among the low court decision among the whether the court will decide determine the intellectual property issues based on the state of the law, the law of the states of the origin, or lex protectionis. However, here the Junki IP, a company incorporated in Korea, acquired the share of the We Made. So We Made split off, split their shares to transfer the Junki IP without any contract. Just it's based on the commercial the code, and actually in this regard, the Actors Soft objected to the this split off, and also We Made failed to obtain Actors Soft's consent, arguing that the Junki IP acquired the share of the co-ownership of the copyright from the We Made by virtue of Article the 530-12 of the Korean Commercial Act, even though it did not obtain the consent from Actors Soft based on the Article 48, paragraph 1 of the Korean Copyright Act. Junki IP granted several Chinese game companies license to use the game in China. So definitely I think the actors we argue that there might be the copyright infringement by the Zhenghe IP in China. So there is several lawsuits among them, but I just focused on the third lawsuit. This is the third lawsuit. Actors Soft brought a lawsuit against the Zhenghe IP for injunctions and damages, arguing that the license contract between the Zhenghe IP and the several Chinese game companies were invalid. The use of the game were the copyright infringement of the game, and the Zhenghe IP aided and abetted them in copyright infringement of the game because the Zhenghe IP did not obtain consent from Actors Soft to grant the license to the third persons in accordance with Article 48 of Paragraph 1 of the Korean Copyright Act. Yes, it seems to me it's a very reasonable argument from the Actors Soft. So according to the look at the procedural fact, the first the court of first instance was the holding of the first instance court is in favor of the defendant. Is for the Korean companies. Actors Soft is a Korean company, but established by incorporated by the Chinese company. If the Korean law was applied to this case, what is why the Korean law is applied? Because it is the law of the state of origin. Second, court decision is almost identical. Why is the holder like this? Because the court held that the Korean law was applied to the case because the application of Article 5, Paragraph 2 of the Berne Convention was extended to the case. The ownership of copyright would depend on the law of the state where copyright infringement took place, resulting in putting the third person wanting to get the license from the copyright owner in unstable positions. That's the reasoning of the court of second instance. So actually, the plaintiffs' attorneys want me to give you the expert opinion to the plaintiff side. So I gave the my opinion to the plaintiff side to avoid the dismissal of this case just before the pendency of the Korean Supreme Court. Actually, it avoid the dismissal. Now it's pending before the Korean Supreme Court. So my expectation is Korean Supreme Court will determine this case based on the transferability issues of the share of the co-ownership of the copyright, applying the Chinese law. So, however, still we have a problem. Under the Chinese company law, there is no split off. However, there is some ordinance about the computer programs. So it might be in favor of the defendant. So which law? Both is mandatory provisions. So even if the Korean law is applied, the split off provisions, whether it's very doubtful whether the split off of the commercial court take the precedence over the provisions on the co-ownership provisions under the Korean copyright law. So the mandatory provisions will take precedence over the other. I think that the court of the second instance made a mistake to apply the provisions of the commercial act. That's my the opinion. Anyway, there's a split the tendency among the low court decisions under the Von Dutch case. It said law of the lex protectionis is a general rule for the all the legal issues, including the transferability of the copyright issues. That's the other cases. So my guess is definitely the Korean Supreme Court will look up to the the ILA guidelines as a good reference, because it's a kind of the uniform and harmonized guidelines absorbing all previous the academic works and the principles and some kind of the drafted conventions. So now move on to the other provisions. 23 guideline 23. It's concerns the employment contract. There is 3 paragraphs. So this is the first paragraph. It's about the party autonomy principles. The guideline 23 paragraph 1 is the sentence 1 is modeled after the Cliff principles. Also, it is influenced by the Rome 1 regulations. So I just skip this part. How about the guidelines 23 paragraph sentence 2 and paragraph 2 and 3? These guidelines provides the fallback provisions in the absence of the choice of law made by the parties. So here, sentence 1 prescribes that in the absence of the choice of law made by the parties, the individual employment contract shall be governed the law of the state in which or following that from the which the employee habitually carries out their work in the performance of the contract. How about sentence 2? It'll be applied to the cases where the employee is expected to resume works in the state of origin after carrying out his works abroad. So, the Kyoto Guidelines is kind of the fascinating from the perspective of the Korean Supreme Court, because sometimes, the guidelines shows the possibility where the court look up to the state of the law of the state of origin. So how about the guideline 23 paragraph 3? This is an exception clause due to the high threshold, so-called more close connection standard. It'll apply to exceptional cases only. According to these provisions, where it is clear from all the circumstances of the case that the contract is more closely connected with the state of other than the state of the law of the state in which you are following that from which the employee habitually carries out his or her work in performance of the contract, the law of that other states shall apply. So there's examples. This case, exception case, applicable to the right to claim a patent right in case of several co-inventors who are habitually employed in the different states. Okay. Also, the guidelines 23 paragraph 1 enforces the mandatory employment regulations of the state in which or from which the employee habitually carries out his or her work in performance of the contract, or of another state where the has more connected with the state in which or from which the employee habitually carries out his or her work in performance of the contract, such as those mandatory implement regulations. The states actually, for example, there are it is the mandatory provisions apply to employees from the employee inventions and the mandatory remunerations for the employee inventions. So in this regard, we need to look up to the Korean Spring case. It is definitely okay.
Professor Lee, please wrap up in 2 minutes. Thank you.
Okay. It is definitely consistent with the Kyoto Guidelines because this case handled the law applicable to the grant of the free non-exclusive license to the employer by the operation of law. So in this case, Supreme Court held that the initial ownership and the succession of the right to patent for the employee inventions and the employee's acquisition of a non-exclusive licensee and the employees the remuneration fall under the legal relationship based on the employment relation between the employees and the employees. So the grant of the free non-exclusive license to the employer by the operation will be governed by the law applicable to the employment relationship. So I wrap up the here. And so definitely Kyoto Guidelines will help the court to decide when there is the lack of the exclusive provisions. So it could be work as a good reference for the national legislations, a good model of supplement for the case law. Also, it could be a good initiative for the international consensus. This is all I have today. Thank you.
Thank you so much, Professor Lee. It's a very good illustration with the doctrinal discussion with the practical empirical studies. Now let's move to Professor Bass. As we know that in recent years, many civil law countries actually begin to follow the example of common law countries to issue injunctions in intellectual property case. Professor Bass will touch on these very contentious and controversial issues. So please, Professor Bass.
Thanks very much, Jean, and thanks very much to Professors Kono and Lee for their wonderful introduction to this subject. Now, I don't wish to lead G to have brought your hopes up to a great extent, because what I'm really going to talk about is in connection with standard essential patents and trying to resolve the jurisdictional issues with reference to the Kyoto Guidelines, which has led to this outbreak of anti-suit injunctions, as Jean was discussing. So let me share my screen. Now, as you probably know, or as many of you will know, the question of standard essential assets and compulsory licensing or licensing of standard essential patents has got a great deal of publicity lately, because what we've seen is a great number of parallel jurisdictions, overlapping cases between various courts, and a whole outbreak of anti-suit injunctions being issued by one court in respect of decisions, awards, and so on of other courts. It's also attracted attention because China is the most recent entrant into this area, of course, as one of the home of some of the world's major mobile phone manufacturers. And so the question is whether the jurisdictional disputes which underlie these problems can actually be resolved, and whether the Kyoto Guidelines can perhaps assist in resolving these sort of disputes. So I'll go back a little bit and just say, what are we talking about here? And this is a very broad brush summary for those of you who really know what they're talking about in relation to patents. Now, what is a standard essential patent? Well, a standard essential patent, of course, is a patent which is necessary for the implementation of a particular standard. So if we look at mobile phones, what makes it possible to use our mobile phones across the world? It's the existence of patents which underlie the standard which is used and required to be used in all the phones, And these patents, of course, are enforced potentially in different manifestations depending on local patent rules in different jurisdictions across the world. But it's generally been conceded that it would not be equitable for the patent holder to be able to refuse to allow other people to operate in, say, the 3G, 4G, 5G market because they can't get hold of the patents. And therefore, the standard organisations, the SSOs, require that the holders of standard essential patents must declare the patents, and they must make them available for licensing by the implementers across the world on FRAND, that is fair, reasonable and non-discriminatory terms. Of course, there can be a lot of disagreement as to what fair, reasonable and non-discriminatory terms are, and there are some discrepancies, or they're generally perceived to be some discrepancies in the sorts of standards which courts, when they're dragged in, apply in setting the rates for these particular standard essential patents. So the basic issue is that the patentee wants higher rates and may force negotiations by suing the would-be patent holders in various different places. The licensee, of course, wants a lower rate and may seek to delay the commencement of the license by failing to negotiate or by questioning the validity of various patents. The problem is that if you're talking about a global rate, that's something which should cross all borders, whereas infringement actions are by their nature domestic, because of course patents are registered in different jurisdictions. And so what this has led to is a whole number of different cases between the major participants in the markets, particularly in the US, the UK, Germany, India, and China. And this has led to a whole range of different infringement and validity cases going on concurrently in different jurisdictions at the same time as there are negotiations or failures to negotiate domestic and global FRAND licensing rates. And if we break it down to private international law, what we have is issues relating to what courts have jurisdiction in relation to setting FRAND licensing rates, what happens when one court's trying to set a licensing rate and other courts are dealing with infringement actions, how to get rid of overlapping actions, and how to deal with things like suits then issuing anti-suit injunctions and respective legal actions which are currently ongoing in other courts. So I'll give you an example here, and this is not particularly to pick on the Chinese courts, but they have very kindly provided for us the most recent of these cases, and it's a case which actually presents all of these issues. So the Supreme People's Court on August the 19th handed down, the Intellectual Property Division handed down a decision in the case of Oppo and Sharp. Oppo is a company and group of companies based in China, which operates mainly in China, which is its principal market. Sharp Corporation, of course, is the head company in a group of companies which hold SEP's standard essential patents in relation to 3G, 4G, Wi-Fi, and various other things. So in 2018, they commenced negotiations, or rather Sharp sent a licensing letter, and they commenced negotiations in Shenzhen. These did not come out with any result. As a result, in 2020, Sharp just started filing patent infringement suits against various companies in the Oppo group in Japan, Germany, and Taiwan. Oppo responded by suing Sharp in Shenzhen for breach of FRAND licensing obligations and asking the Chinese courts to set a global royalty. So all of these cases were going on concurrently. The Shenzhen court then ordered that Sharp not file any new lawsuit or any judicial injunction against Oppo companies, and in particular, it issued a non-enforcement order against a decision of the Munich court to grant an injunction in Germany in respect of Oppo's infringement of a license. So the Munich court immediately responded by issuing an anti-suit injunction to Oppo. The Shenzhen court threatened consequences against Sharp, which withdrew the anti-suit injunction. And in 2021, the IP division of the Supreme People's Court confirmed that the Shenzhen court had jurisdiction. It was the appropriate court to consider the case, and it had jurisdiction to determine a global rate. Now, how does that fit in with our discussion on Kyoto, if we look at jurisdiction there? The first point that we need to find here is what is the appropriate court for all of these various actions? And the basic principle that the Kyoto Guidelines outline in respect of jurisdiction is that the court of the defendant's habitual residence or site of its main business activities has jurisdiction. And the advantage of suing the defendant under the Kyoto Guidelines would be that the jurisdiction of the defendant's court would be unlimited as to substance and unlimited as to territorial scope, thus offering potentially a venue where all of these decisions could be resolved. Now, it should be noted that in the Oppo and Sharp case, in fact, Sharp did not have a domicile in China, nor did it have any business activities in China at all. So in Sharp, what we ended up with was the court of the plaintiff's habitual residence. Now, this rule in relation to the court of the defendant's habitual residence runs concurrently in the Kyoto Guidelines with the jurisdiction of the court of the state for which a license is granted or where a right is transferred, which we've already heard about from Professor Lee. Guideline 5 says that the court of the place where the infringer acted to initiate or further an alleged infringement, or the courts where infringement caused substantial and foreseeable injuries would have jurisdiction. And Guideline 8 tells us that the court of the state where the intellectual property right exists has jurisdiction in cases concerned with title and ownership, whereas under Guideline 11, the court of the place of registration has exclusive jurisdiction over proceedings which have as their main object registration or validity, etc., of rights. Now, if we look at the issues in relation to standard essential patents, are these going to be of assistance to us in terms of resolving the sort of disputes which we get in these cases? So if we say, for example, that the one court which has jurisdiction in all circumstances is the jurisdiction of the defendant's court, this certainly has advantages in terms of simplicity, and it would give the defendant's court the right to deal with presumably the entire dispute. So potentially infringement and potentially issues relating to setting the FRAND license and so on. So potentially it would cut down forum shopping. Instances of forum shopping I've noted here are Samsung and Ericsson, where Samsung decided to sue Ericsson in China because they thought they could get a lower rate, and of course Oppo and Sharp. The problem with this is that essentially when you look at standard essential patents, you have multiple patents, you have multiple patent holders because all these big companies all operate in groups, and you have multiple potential licensees. So just because you're licensing Huawei, for example, doesn't mean that you're always licensing the same Huawei company. You may be licensing a whole different collection of companies within the Huawei group. Now, the guidelines attempt to deal with this to some extent by, in Guideline 7, providing for consolidation. And under that basis, the court of the defendant's domicile would be able to add other defendants not habitually resident if what we're dealing with is the same intellectual property. And the same intellectual property has to be closely connected claims or matters with a substantial connection between the intellectual property rights at issue and the dispute. However, in our case, where we're talking about a sort of global rate setting dispute, this is not necessarily going to be close enough because the patents are not going to be necessarily the same because patent rules are different across jurisdictions, as I mentioned, so the patents are not necessarily identical. And similarly, of course, the licensees are not identical either. So you may not be able to use the consolidation provision, in fact, to bring all of the potential parties in. Secondly, when we look at the way the current cases have developed, although there are some exceptions, such as the Samsung and Ericsson case, on the whole, these cases don't appear to originate in the jurisdiction of a particular defendant. In fact, where they often seem to start is where the patent holder decides to sue one of the utilizers of the patents for infringement, and or the licensee responds or initiates actions querying the validity of the patents. The infringement and the validity goes along together. And in these cases, essentially what tends to happen is that the courts are fairly jealous of their jurisdiction when it comes to infringement claims. So although the Kyoto Guidelines essentially contemplate a situation where you could have a court which is not the place of registration determining validity of a patent as between the parties, and therefore also potentially determining infringement cases other than the place of registration of the patent. In practice, if you look at the court decisions, the courts have a tendency to say, as Professor Kono was mentioning in relation to Lucasfilm and Ainsworth, that they have jurisdiction always to deal with infringement and validity cases of patents which are registered in their jurisdiction, and they intend to continue doing so no matter what cases are going on overseas that may be potentially related to this. So trying to persuade causes not to maintain jurisdiction over these infringement and validity actions is always going to be difficult. And I think that the third factor, which is going to make it difficult to actually use the Kyoto Guidelines in this particular respect, is that the current trend seems to be expansionary rather than otherwise. So in the very famous case in the UK of Unwired and Huawei, what the court decided to do in that case was they offered Huawei, as the infringer of the patents in the United Kingdom, a choice. They said you can either have an injunction against you in the United Kingdom, which would essentially stop you from accessing the UK market, or you can accept a license for a global license for the FRAND rate, which we will determine for you. And the court then went ahead and determined it. And inspired by this, the Chinese courts have also then moved on to granting a global rate. I should say a number of the US courts grant a global rate too, but that has all been by consent. So if we look at the decision of the Intellectual Property Division of the Supreme People's Court in Sharp and Oppo, as I mentioned, they held that they did have jurisdiction, but they held this on the basis of a number of interesting concepts. So remember, Sharp didn't have a domicile in China, this was agreed, nor did it have a place of business in China. So what then would be the basis for the court exercising jurisdiction other than the Chinese patents, which in and of themselves would not be enough to justify the court in granting a global rate? And what the court said was, well, we will look at the place of negotiations, the willingness in the original offer, remember which failed, of Sharp to have a global rate, the place of implementation, if there was a license, manufacture and source of revenue, the vast majority of which would be in China. And on this basis, the court said, well, clearly we do have jurisdiction and we will therefore fix the global rate. Now, if you look at the Kyoto Guidelines in comparison, we see that in Guideline 16, the drafters clearly set out what they thought were insufficient grounds for a court to exercise jurisdiction. And these included things like nationality, the presence of non-related assets or non-related commercial activities, the residence of the plaintiff, the presence of the mere presence of the defendant in the jurisdiction, which would cut out a lot of common law courts, and completion of formalities necessary to execute an agreement. So I fear that even though the option offered by the Kyoto outline in this respect is promising, it's going to be very difficult to actually implement given this particular trend. Which of course has to do with our final points, as I know Jean's going to tell me to wind up very soon, which is the question as to whether we can avoid the parallel proceedings and the parallel overlapping cases and hence anti-suit injunctions. And we have two issues here. The first is, if you have two courts hearing the same case, how do we determine which of them should have priority over the other? And the second is, in our particular context of rate setting for the license and infringement and validity proceedings, are these the same case or are they not? The UK court, I think, said very clearly that in fact they are related, because the answer to your action for infringement and validity in the UK in that particular case was to grant Huawei a worldwide license. And the court said it's contemplated really in relation to this sort of negotiation that some of the patents may be invalid, but you could resolve the whole thing by having a license. And the Chinese court essentially said the same thing in one of their earlier cases, in Xiaomi and Wired. But in the latest Supreme Court case, they said, no, infringement and validity is not at all related to FRAND licensing. And that's what the US courts and other courts have said as well. So you could presumably have one court trying to set a global rate for a FRAND license, while in the other courts, you still have these domestic infringement and validity cases going on, which rather negates the point of having the license. And this is something which is rather too complex, I think, to be easily resolved. There is, I think, a good attempt made in the Kyoto Guidelines to deal with this in relation to parallel proceedings by saying that the first court has to consider its position and the second court essentially has to stay its proceedings until the first court has decided whether it has jurisdiction. So it's essentially a first in time, unless you assume that the first court will actually not take jurisdiction, which I have to say very rarely happens. And the second thing is that a parallel proceeding actually has to be something which is really almost identical. And as I've already said, I think that's very hard in terms of patents because they're not necessarily identical. They may have the same purpose. The package will have the same purpose, but the individual patents may not. So since I'm well over my time here, I will stop and hope that I have not contributed to the confusion here. But the conclusion, I think, is that I think the Kyoto Guidelines make an excellent contribution to trying to clarify these really difficult issues in relation to jurisdiction and intellectual property. But I think current judicial trends are leading in the different and the wrong direction. And it remains to be seen whether this can be wound back by the exercise of some rationality.
Thank you very much, Vivian. So we immediately have a question for you. So one attendee asked, when there is a standard essential patent conflict between the parties, whether the parties can choose to file a lawsuit in the courts of more than one country, if these countries and the parties are of the same degree of relevance, can Kyoto still provide the guidance? I think actually you already addressed this issue, but just wondering if you would like to add anything.
It depends really what sort of lawsuit, because remember, patents are domestic. So you could infringe the same patent in France, Germany, the UK, and the US, or substantially the same patent, but they would be different patents, in fact, because they're in the UK. And as the Kyoto Guidelines say, if you were challenging validity, for example, you'd have to challenge your UK one in UK, you'd have to challenge the US one in the US. The consolidation provision, I think, could be very valuable, but it's certainly the guideline commentary sort of specifically notes that in relation to patents, unless you're really talking about something like the European Patent Office or European patent, then it's not going to be likely that you could consolidate in that particular case.
Okay, thank you very much. So let me just post another reply. Okay, so thank you so much. I think we already addressed all the questions. So just 1 more minute for additional questions. So one attendee asked, I understand that Article 11.2 says, however, the resulting decision should not have any effect on third parties. So in which extent the decision is binding to the parties who are losing party asked to review the case again. So Professor Kono,
Okay, thank you very much for this question. The Article 11, if I may, maybe I could share the screen. I hope that it works. Can you see? This is the language of the guideline 11, para 1 and 2. And the para 1 says that if the validity is the main claim, that then the court of the state of registration has exclusive jurisdiction. So if somebody brought a case based on 11.2 Article 11.2 in a court, then this court does not have the jurisdiction on the validity as a main claim. So whatever this court, based on 11.2, says in its judgment, this judgment, as long as it is a main claim, the validity is a main claim, this court has no legal, legal ground, i.e. there's no jurisdiction. So it is very possible that losing party could claim the validity based on 11.1.
Thank
Could
you
I
so much.
just add there, actually, I think part of the question is how you look at it this way. If someone brings an infringement claim and the other party defends on the basis that the patent is invalid, as Professor Kono was saying, if you actually want to invalidate the patent in the sense of having it knocked off the register, you have to do that in the jurisdiction where it's registered. But if you're doing it essentially as a contractual matter, you're saying, I'm not liable to pay you anything because it's not valid, then another court could determine that. But that doesn't mean that someone else who came along would necessarily get the benefit of that decision. The patent holder could still sue the third party for breach of the patent because it's not really invalid in the sense that it's been taken off the register. It's just been held invalid as between those two parties.
Okay, so we are run out of time. I really enjoying this wonderful discussion, both by our speakers, and also we have a lot of QAs via the chat function, and the slides of our speakers will be made possible and will be emailed to the registered attendees by our wonderful event managers here. And so thank you so much for our wonderful speakers, Professor Kono, Professor Lee, and Professor Bass, for your time and knowledge and your great, encouragement for our younger students. And thank you everybody for spending the Friday afternoon with us. Thank you. Bye-bye.
Thank you very much.
Thanks,
Bye-bye.
Toshi.
Bye-bye.